So what happens when the exact same set of facts leads a court to two completely different conclusions? Today, we're going to dive into a legal puzzle that actually split Pakistan's Supreme Court, turning a case that seemed pretty straightforward into this huge debate about justice itself. Okay, so on the surface, the facts of the case seem pretty cut and dry. A man, Hassan Khan, is accused of rape. A child is born, and a DNA test confirms he is the father. The evidence seems locked in, right?
And based on all that, the lower courts handed down a really severe sentence, 20 years of rigorous imprisonment. The stakes for everyone involved were, incredibly high.
But then, something happened. When this case made it all the way to the Supreme Court, the judges fractured. A 2-to-1 split decision emerged, and it completely challenged that initial verdict. And the result of that split? Well, it was absolutely staggering. The majority didn't just reduce the sentence. They completely reclassified the crime. What the lower courts called rape, which came with a 20-year sentence, the Supreme Court majority decided was actually fornication, carrying only a 5-year sentence. So this brings us to the big question, right? How? How can the exact same evidence lead one group of judges to a verdict of rape and another to fornication? Let's unpack the arguments. First things first, let's just lay out the basic events of the case that both sides of the court actually agreed upon. Okay, so here's what's not in dispute. A woman, Miss Farhat Bibi, alleges she was raped at pistol point. The official police report wasn't filed until 7 months later. After a child was born, a DNA test confirmed Hassan Khan's paternity. And based on all this, the trial court and the high court convicted him of rape and gave him that 20-year sentence. Now here's where things get complicated. The first major point of disagreement all came down to one detail, that 7-month delay in reporting the crime. You see, this delay became a huge battleground for interpretation. Did her silence for 7 months mean her story couldn't be trusted? Or was it a perfectly understandable reaction, stemming from fear and societal pressure? The judges were on completely different pages about this. The majority found the delay really suspicious. They actually wrote that it speaks volumes against her conduct. But the dissenting judge, he saw it through a totally different lens, one of trauma and social context, arguing that an unmarried orphan would, of course, be reluctant to come forward. And the dissenting judge, Justice Panhwar, really hammered this point home. He said, and I'm quoting here, that the court can't ignore the prevailing taboos in society. His point was that a victim should never be penalized for a delay that's often just born out of fear and shame. All right, next up, the second big disagreement. This one was all about the physical evidence, or more accurately, the lack of it. So this raised another really tough question. The medical exam happened months later, and it found no marks of violence. So does the absence of a struggle automatically mean the act was consensual? And again, the judges were split right down the middle. The majority focused on everything that was missing. No signs of a fight, no physical injuries. But the dissenting judge, he focused on what was there, a weapon. He argued that the fear of harm from a pistol would paralyze someone, which would totally explain the lack of a struggle. And that brings us to the final and maybe the most technical point of contention, the DNA evidence itself. So the defense team really zeroed in on a significant delay. Look at this timeline. The cheek swabs were collected way back in late 2015, but the actual DNA analysis in the lab didn't happen until May 2017. That's almost a year and a half later. So the majority judges, they looked at that gap and thought, that's a problem. They pointed to research saying buccal swabs can break down pretty quickly, and they raised a serious question about the DNA report's authenticity. But the dissenting judge, he basically called this a fallacy. He explained that modern labs don't just let the swab sit around. They extract the DNA from it right away and preserve it. And that preserved DNA, he argued, is stable for years, so the delay didn't matter. So there you have it. You've got these 3 huge areas of disagreement: the reporting delay, the lack of physical resistance, and the validity of the DNA. And that's what led the court to its pretty shocking final decision. In the end, it all came down to a 2-to-1 split. With just that single vote difference, the majority opinion won, and the entire legal foundation of the case was completely overturned. And this is where it gets real. The actual impact of that legal debate was huge. The conviction for rape was thrown out. In its place, Hassan Khan was convicted of fornication, and his sentence was slashed from 20 years down to just 5. So let's break this down, because it's really the key. The legal difference between these two crimes, it all boils down to one word: consent. Rape is non-consensual. Fornication, under this specific law, is defined as willful or consensual intercourse. But the dissenting judge had one last really critical warning. He argued that just because the prosecution fails to prove rape beyond a reasonable doubt, it doesn't automatically prove consent. He thought the majority had made a dangerous leap, basically assuming consent just because their high standard for proving rape wasn't met.
You know, when you really look at it, this case is such a powerful reminder that justice isn't some simple machine where you just plug in facts and get a verdict. It's a process of human interpretation, where things like context, social norms, and just different ways of looking at the law can lead to wildly different outcomes.
And that leaves us with a really tough question to think about. When the most experienced legal experts in an entire country can look at the very same set of facts and see two completely different crimes, what does proof beyond a reasonable doubt really, truly mean?